Thank you very much, Earl, and thank you, David, for bringing me back this year. I really appreciate it, and good afternoon to everybody today. It's a beautiful day here in Niagara Falls, and I hope it's beautiful where everybody else is. So in terms of what I'm going to discuss today, there's going to be what I call a potpourri of Tax Court of Canada, SR&ED topics, and a summary of the Department of Finance 2021 tax expenditure analysis as it relates to SR&ED matters. So on the two Tax Court of Canada potpourri issues, I'm going to do an outline of the TTC rules, both general and informal procedure on costs, and do a review of all the TCC SR&ED decisions that are available on the TCC website from 1996 to date. So it's a fair amount of time.
Oh, wait, I got to share your screen. I'm sorry. Are we good now?
Yeah, it's starting to come up. There we go. Yep. Now we're good.
Okay, I'm going to get out of your way.
That's okay. Third time's a charm, guys. Sorry about that. We're back. So just a bit of a summary there. I'll go back to the first point. So I'm going to do an outline of the TTC rules, formal on the issue of costs as they relate to TCC SR&ED cases. And I'm going to look at a fair period of time from 1996 to date. And we're going to see in whatever fashion costs are addressed and attempt to provide guidance to accountants and tax lawyers on how costs are dealt with in these matters. Then I'm going to look at a quirky section, I should say, of the TCC rules for general procedure, section 6, and note the problems that it raises and how they are addressed. And then finally, I'm going to do a review of the recently released Department of Finance 2021 tax expenditure analysis as it relates to SR&ED matters. So, down. It's not working. Okay, sorry, go back. So first of all, we will take a look at the court. Just as I get my bearings here. Sorry, everybody. So, is this showing up on your screen at all?
Yep.
It is. Okay, good. Excellent. So I'll start with 147, and believe me, it's not going to be a painful legal lesson. We're just going to do a high-level overview. I'll just preface my comments at the beginning. So section 147, we start off with the general principles. So this is under the general rules. And what I should note here is, although there is very little in the informal rules on the issue of costs, there is nothing preventing a tax court judge from analogizing to the general rules, and it's done all the time. So section 147 really is the charging section, and it really provides the basis for costs and what costs in terms of what the court is going to look at. What are the parameters and what are the criteria? So it indicates that costs may be awarded to or against the Crown, and that there is a fair bit of discretion. And what is that discretion? So it's going to look at the results of the proceeding, the amounts in issue, the importance of the issues. Is there a public policy bent to one of the issues? Any offer of settlement that was made in writing? How much work was involved? Were there a lot of experts? The complexity of the issues, the conduct of any party. In other words, do we have a vexatious litigant that's involved in this matter? Was there a denial or neglect or refusal of any party to admit anything that should have been admitted? And that whether at any stage in the proceeding there was improper, vexatious, or unnecessary behavior, was there anything taken through negligence, mistake, or excessive caution? And then it deals, I.1 deals with expert evidence. And then 3.1 and 3.2 deal with the settlement issues. What were there offers to settle and how were those offers to settle dealt with? They are really useful tools when it comes to costs. 3.3 also deals with offers to settle. And then there are 3.4 also deals with the burden of proof. 3.5 goes on to address substantial indemnity costs. And 3.6 assists in that way. 3.7 deals again with the determination. 3.8 deals with communication on offers to settle. So now sub 4 deals with Schedule 2 Tariff B. And of course, again, the court is not wed to Schedule 2 Tariff B, and we will take a look at that. But it is a starting point, and really that's all it is a starting point. And again, there is discretionary power noted in sub 5. Sub 6 speaks to taxing officers, which are used, and what directions that the court can give to taxing officers. Sub 7 deals with any party may within 30 days after the party has knowledge of the judgment or after the court has reached a conclusion as to judgment to be pronounced at the time of the return of the motion or judgment, whether or not the judgment included any direction concerning costs, apply to the court to request that directions be given to a taxing officer in order to deal with the matter. And I'm just going to move on to the next page here. So costs on a discontinuance. So in other words, that's where the matter really has stayed and it's settled and it's going to be discontinued. In other words, it's not going to be proceeding any further, and the parties will agree to that. So where under section 16.2 of the Tax Court of Canada Act, a party is discontinued of proceeding, the other party may tax the cost thereof, and if the tax costs are not paid within 4 days after taxation, may enforce payment as if judgment therefore had been granted. 149 deals with costs on a settlement, where a proceeding is settled on the basis that a party shall pay or recover costs, and the amount of costs is not included in or determined by the settlement, the costs may be taxed under sections 153 to 159. I'm not going to go through the taxing sections. They're there for us to take a look at, but I'm not going to go through them today. I'm going to finish off at 149, costs on failure to elect under subsection 18 sub 1 of the Act. So on an appeal under the ITA, the court may refuse or reduce costs payable, otherwise payable to an appellant who, in circumstances in which the appellant could make an election under subsection 18.1 of the ITA, does not make such an election. And then we'll see taxation of costs starts at 150, and I believe it runs through to 159. So going back to the slides, I'm going to look at Schedule 2 now, and this is going to be the tariff. So I'm just going to go down. So the first part, of course, the Tariff A, that really deals with what type of a matter it is. Is it going to fall under a Class A proceeding, a Class B proceeding, and a Class C proceeding? Now that's important because
Angela, they can't see. You need to share that screen.
Okay, my
or maybe
apologies.
just talk to them about it at a high level.
Yeah, that's what I'm doing. Just doing tie level.
Okay.
Yeah, I
Sorry to
don't.
interrupt.
Yeah, no, that's okay.
They won't be able to see your link.
Sorry. So yeah, so you're not seeing the links that I'm bringing up. What I'm doing is I'm bringing up the sections. Do you want me to share the screen so that you can see this?
You can.
It
just
might
have
be
to switch
useful.
back.
Yeah, I think that'd be better.
Yes,
Okay.
I'm sorry.
You're gonna have to do this then for each one. There you go. Should be sharing that one now. Okay.
Yeah.
Perfect.
Thanks.
Go ahead.
That's great. Thanks. So which one is it again, David?
So now you're just gonna scroll down.
No, but when I want to go up, it's stop share, or you are on the green?
Yeah. So you'll go stop share or new share.
New share. Okay.
I'll be right around. I'll hang around here.
Thanks.
Okay. So now you can scroll up now. Sorry
Perfect. Thank you. Sorry about that, guys. We're having lots of tech issues here today.
We're learning. First
Yeah.
time on Zoom.
Yeah, very, very sorry. So if we go down to Tariff B, so again, these are baselines, and the tax court is not wedded to any of this. But what this can provide is a bit of assurance anyway, that in a Class A, B, or C proceeding, that you are likely, if you are successful at the tax court, that you are going to get something, and that you're going to get a baseline in the vicinity of these amounts, depending upon which class you're in. So if you're looking at 1A, for all services in a proceeding prior to an examination for discovery, not otherwise listed in the following paragraphs, we see there the amounts range from $350 to $700. For a discovery of documents or an inspection of property, you're dealing between $100 to $200. So these amounts are fixed amounts, and they are not by the hour, just so everybody knows. But again, they are baselines. C, for a motion, examination for discovery, a taxation of costs, taking evidence before hearing or cross-examination on an affidavit. So that's a little bit higher. You're looking at $350 to $700 a day. A preparation for attendance at a pre-hearing conference, So that would be like a case conference or a settlement conference. You're looking at a baseline of $350. If you have to attend a status hearing, $125. So a status hearing would come up in the event that the parties have let a matter languish, and they've not done a timetable and they've not moved the matter forward, and it's at risk of actually being dismissed. And the court clerks, the registry office will send something out, and they will say that there has to be a status hearing and you need to attend, or prior to that, the parties can agree to do whatever steps need to be done so that no one has to attend the status hearing. If there is an agreed statement of facts or an agreement regarding documents or notice to admit. So these are all things that would be done prior to trial. And again, you're looking at baselines at $270 to $500 an hour. Preparation for a hearing, very important for accountants who are involved in SR&ED matters. So you're looking at baselines of $350 to $950. Obviously, the more complicated the matter, the more money you're going to want to seek. And you're going to want to seek that discretion from the court. For conduct of the hearing, for every day that you're involved, you're looking at $1,000 to $2,000, depending upon what class you're in. And then, of course, for all services after judgment, and now this would definitely come into the issue of costs. If you had to be involved in providing any submissions on costs to the lawyer that was involved in the matter, you would be looking at $150 to $450. So that's the tariff. And now I'm going to go back to, with the assistance of David.
And back to screen 2. I think you're good.
Okay, perfect. So now, thanks. So now we're going to look at the very few rules that exist under the informal rules on the issue of costs.
So you have to do the same thing.
Okay, so I go up here.
If you want to show that to me.
Yeah, I do. So I'm going to go share, new share.
Yeah. There you go.
Perfect. So
Be an expert in no time on Zoom.
So you just want to click down here on this screen.
okay, great. Thank you. Perfect. So we're going to go all the way down to section 10, because there's not many rules, of course, in the informal. So costs comes up. The court may determine the amount of costs and allocating them. 2, may award costs to a respondent in amount not exceeding the amounts listed in section 11. Only if the actions of the appellant unduly delayed the prompt and effective resolution of the appeal, the court may direct payment of costs in a fixed sum in lieu of any tax costs. And then section 11 on the taxation of party and party costs. So again, this is like a mini tariff that's included here. The following fees may be allowed for the services of counsel. So we're not dealing with accountants. In the preparation of a notice of appeal, hearing, conduct of a hearing, and taxation of costs. 11.1, unless otherwise directed by the court where an appellant is represented or assisted by an advisor other than counsel, so this would include accountants, the disbursements in respect of services referred to in section 11 may be allowed on the taxation of party and party costs in an amount not to exceed 1/2 of the amounts listed above in section 11. 11.2 sub 1, such other disbursements may be allowed as were essential for the conduct of the appeal if it is established that the disbursements were made or that the party is liable for them. And 2, there may be allowed all services, sales, use, or consumption taxes and other like taxes paid or payable on any counsel fee disbursements allowed if it's established that such taxes have been paid or are payable and are not otherwise reimbursed or reimbursable in any manner whatever, including without restriction by means of claims for ITCs in respect of such taxes. 12.1 deals with witnesses. So other than a witness who appears to give evidence as an expert is entitled to be paid by the party who arranged for his or her attendance $75 per day, reasonable and proper transportation and living expenses. And then there are amounts, amount is not payable under subsection 1 in respect of an appellant. 2, there may be paid to a witness who appears to give evidence as an expert, a reasonable payment not to exceed $300 per day, unless the court directs otherwise. So again, there is so much discretion that is built into these rules. The court can make, whatever decision he or she sees fit, so long as, counsel or agent provides, a basis for same. 13 then goes on to talk about costs taxed by the registrar. And then 14 deals with the vexatious no, sorry, 14.1, any party appeal to a judge of the court from taxation, such appeal is to be exercised by notice in writing to the registrar within 20 days. And then 14.1 is the broad rule that provides the court with authority to deal with costs in vexatious proceedings. Yes, do you mind, David? Thanks. So now we're going to take a look at the decisions. Yeah, thanks. That's perfect, David. Yeah, no, the one before. So review decisions from the TTC website, SR&ED Matters, from 1996 to date. So I've prepared a PDF that David has sent out of all of those decisions. So of the 58 that there are 47 of them that address costs in SR&ED Matters. 12 of them are informal and 35 are general. So the number of informal matters where costs were awarded, and when I use costs being awarded, that phrase, I'm referring to costs on an affirmative basis. There were 2. And then the number of general matters where costs were awarded on an affirmative basis, there were 21. And then this is the breakdown of the decisions that were provided. And again, we're not getting much guidance here, sadly, from the court in SR&ED Matters on costs. So orders are willing to hear submissions from counsel on question of costs, or counsel asked to make submission. And that really is what is happening in these matters, and I'll address that as I go forward. So there were 2 of those. Costs were awarded in accordance with the tariff. There were 2. If parties are unable to agree on costs, they may make submissions in writing not to exceed a certain number of pages. 4. And again, that's the usual order. 1 party is entitled to costs. 4. The appeal is allowed or dismissed with costs. That's it. 18 of them. Costs in the lump sum of a certain amount, only 1. Appeal allowed or dismissed without costs, there were 9 decisions. No costs awarded to either party, there were 5. Each party shall bear their own costs, there were 2. Costs in the cause. So just to explain what costs in the cause it means is that costs of the interlocutory proceeding that is before the court, and in these instances, these would not be final matters, these would be motions. They would abide by the eventual trial result. And then costs in any event of the cause, there was 1. And again, that would be an interlocutory motion. So it means that a named party is entitled to costs of that interlocutory proceeding, a motion, regardless of whatever the final result of the action is. So, and I just want to note here that although there were 47 cases, there were a few decisions that are in more than one box. So I've got, my numbers add up to more than 47, just so that everybody knows the math. So we only have 1 decision, which is a shame, that deals with costs on a substantive basis, and it deals with a vexatious litigant to provide us with any guidance in SR&ED Matters. It's an informal matter. It's Foster and the Queen from 2007. And I've put the paragraphs, I've quoted them, that address the issue of costs, where the respondent, the court makes a vexatious order against the appellant. In this case, it's the respondent that is seeking the costs, the Crown, the DOJ Tax Law Services, and I think in the end there was paragraph 66, there was a lump sum of $3,000. And you'll see here in paragraph 65, this passage was adopted in Fournier and the Queen. It's a federal court of appeal decision that said that this court, in other words, the tax court, has the inherent power to prevent and control abuses of process by awarding costs. So the court has inherent jurisdiction at the tax court to control its own process in every way possible. And part of that is controlling the administration of justice and awarding costs when they see fit. So the question is, why are there so few reported cost decisions by the tax court in SR&ED Matters? And the reason being is that given the length of so many of these hearings, in order to cut down on court time, the court will often receive submissions on costs from the parties and render a separate cost decision to the parties only. Now, these cost decisions are not reported by the Tax Court of Canada, rarely if ever. And I have to say that this is unlike cost decisions in civil litigation and domestic family matters, just as an example. And when I speak of civil litigation, I'm talking of commercial, bankruptcy, really any other area of law, where ancillary cost decisions are rendered all the time, and they are reported as addendums via the legal research platforms, which I'm sure you're all familiar with: Westlaw Next Canada, Lexis Advanced Quick Law. Those are paid services, and Canley, which is of course complimentary. So the reason why they're not being reported, I don't know. It's a very good question. They're not, and it's not common course in the provincial courts for that to be the case. So that's the Ontario Court of Justice and Superior Court here in Ontario. So the question is, and David and I were having this discussion, now what? What do you do? How can you get a sense of how costs are being determined in SR&ED matters? So there's two ways that, there's two possibilities, and they both take some legwork. So one is to contact the parties or the lawyers directly with respect to a particular SR&ED decision and ask them if you could review a copy of the cost decision. That's the best option. If you're not able to do that, if you do try to reach out and they don't reply to you, you can then contact the TCC registry office to see if it would provide you with a copy. But you have to be mindful that they would have to obtain consent from the parties in order to release it. So that's not the route you want to go. The better option is to do the former. So that's where we're at on the costs. So in terms of, are you going to get costs if you win? Yes. You're going to get the base costs, no doubt, that are in the Tariff B. But there will be discretion of the court, and there's no likely that you're going to get, very likely that you are going to get higher than that. So moving on to topic 2 of our potpourri of tax court issues is the issue of recording teleconferences and video conferences at the TCC at the request of the parties in general procedure matters. So this is a section 6, that is not included in the informal procedure matters. It is only included in, rules, only included in the general rules. I have to do this first. Yeah, right. Share. So I'll just take us through the section 6. It's a very, very brief, very, very small section. But it creates a bit of havoc. So it says hearings by video conference or teleconference. The court may direct that any step in a proceeding be conducted by teleconference, by video conference, or by a combination of both, and may specify the party responsible for establishing the communication. So the issue here is, who is going to establish the communication? It's actually going to be a party. So it's going to be a taxpayer, or it's going to be the lawyer from the Department of Justice Tax Law Services. So what guidance do we have on this by the court? So I'm going to go back now to the slides. And sadly, like we are with the costs, there is this section has only been interpreted and had one piece of treatment in 1995, addressed section 6, and it's not on a substantive basis. So the Odisha professional corporation case is not at all, doesn't provide us with any assistance at all. In terms of the, and it should be informal, sorry about that. Can I go down here, Dave, to see the rest of this script? Is that the last of the page? Yeah, oh, okay. Okay, so that's fine. So we'll move on. We're missing something there, but no problem. So the question is, if parties are arranging teleconferencing or video conferencing of a matter, who is responsible to record it? So this is a huge problem, not just for the tax court, but this is an issue that arose very early on in the pandemic last year in the provincial courts of the province, in the Ontario Court and in the Superior Court of Justice. Because the issue is, if you're having a taxpayer or the Department of Justice Tax Law Services lawyer setting up the teleconference or the video conference, so the teleconference will be through whatever line they're using, Bell Canada, Ring Central, who knows, video conference, are they using WebEx, Zoom, Microsoft Teams? There are so many of them out there. And they are creating a recording of this. Is that an official recording? And the answer to that question is no, it's not. There can only ever be one official recording of a matter, and it has to be done by the court. It cannot be done by a taxpayer, and cannot be done by a Department of Justice lawyer. So I'm going to show you now the reason why that's the case. And this has been, I was in touch with the chair of the Tax Court of Canada Bench and Bar Committee on this issue, and it's a live issue that is they're dealing with right now at the court. One of the biggest problems at the tax court has been that it doesn't have the infrastructure, sadly. It's lacking the resources in order to really control its own process when it comes to the administration of justice on the technical end of things. The tax court does not have the infrastructure to run virtual hearings. It didn't have that infrastructure prior to the pandemic. It didn't have it during the pandemic, and it doesn't have it now. There have been allotments provided to the court. There is a separate entity, government entity, that controls the administration, the technical administration, of justice at the federal court. So at the tax court, the federal court, and the Federal Court of Appeal. And there just aren't enough resources that have been allocated to the tax court in order to do video conferences. And that has been a huge setback for the tax court, of course, as we all know, because they've not been able to keep up like the Ontario Court and Superior Court has, at least in the province of Ontario, with hearings. And there's going to be a huge backlog at the tax court that's going to have to be dealt with. Now, Chief Justice Rogerson has said that they're going to try to deal with this. He wants to move forward. He wants to use video conferencing, but there has been a pushback, and there has been an issue of resources. But I want to share this screen now. So this is going to help us to understand why there can only be one transcript. So this is from the Tax Court of Canada website. You'll see that they've just redone their website now. It's really nice and swanky. So after the hearing, sorry, this is not. So the question is, the hearing is done, and it's not just hearing here, so hearing in the sense of a trial. We're dealing with conferences and motions, etc. How do I obtain a copy of a hearing or transcript of an audio recording? You may obtain a copy of the full transcript of your hearing by contacting the reporting company directly. The reporting companies are determined based on the province where the proceeding was heard, and you may refer to this chart, and we'll go there in a second, in order to order it. Following a hearing, parties can request a copy of a CD or a recording of their hearing. In order to obtain this, one must be a party to a file. A request should be submitted to the registry office in writing, detailing the appeal number and the date of the hearing. An undertaking form must also be signed and sent along with the written request. Once the request with the signed form is received, a CD will be mailed. Please note at this time, audio cannot be sent electronically. So going back to share and the screens and the slides, how do you obtain a copy of a transcript of an audio recording, or of a video recording for that matter? And I'm going to take you to the court reporting and transcription fees page, because this has very useful information, although it's dated from 2016 to 2017. As I was preparing the slides for this presentation, they've actually pulled this page down, and it says that it's in construction. So I suspect that they've got a new reporting agency right now that has got a contract, because there are bids on all of this. Yeah, okay, thank you. That's perfect. Thank you. So this is useful in that it shows you that at least in 2016 and 17, the ASAP, so ASAP Reporting Services, was involved in terms of doing the recordings. And so they have access to everything from the federal court, Tax Court of Canada, Federal Court, and Federal Court of Appeal, what we consider our federal courts. And you'll see here that they give there's all kinds of pricing that is included that's useful. And there's also a link to how the transcript is in fact supposed to be requirements relating to transcripts, but it's not necessary for us to go through that. I'm just going to go back now to share to the slides, and you'll see here this ASAP. I've had to do this a number of times. So I'm just going to show you this in case this is something that ever comes up and that you need to look at. This is how you actually go through to do a request to order a Tax Court of Canada transcript, whether this is of a, sorry, we always have problems when we move between screens with the mouse here.
All the way to the right.
Yeah. Perfect, thanks, David. So, perfect. So, So you'll see here that certified court transcripts, order and transcript. I'm just going to go here so that you can see how this. Okay, so a transcript of a proceeding. They would all be ASAP reporters because they've got the contract, and then you would just go ahead and start to fill this out. You would need the court file number, style of cause, what was it? Was it an examination for discovery at the tax court, and what type of a proceeding was, and then you would submit your form and then payment. So we'll move on now to. Okay. Oh, sorry. Yeah. Sorry. Okay. All right, so that's the issue with the recording. And as I say, it's a live issue. I emailed one of the executive legal counsels at the Tax Court of Canada to get some information on Section 6, Rule 6, I should say, of the General Tax Court Rules. And she got back to me last week and indicated that she had passed on my request and that she was hopeful to get back to me soon. And sadly, she wasn't able to get back to me in advance of today's presentation. So when I do hear back from her, I will proceed to send off the information to David so that he can circulate it to everybody, because it certainly is an issue that the tax court is live to, and that you know, there are certainly issues with recordings. The tax court knows that this is how you know, things have to be done. So moving on to the final topic that I've got, which is the analysis in the 2021 Department of Finance Tax Expenditure Report. I'm just going to click on it here and bring it up. So I'll leave it here. I'm not going to flip it to pages, and I'm just going to reference some pages here, and you can certainly look at the document at your leisure. But some of the things I just wanted to highlight quickly, that on page 29, part 2, it presents the estimates of the fiscal cost of the federal tax expenditures for the years 2015 to 2022. And then on page 31, it starts to look at exactly what these are in millions of dollars, what they are costed at. So PIT, the acronym refers to personal income tax excluding trusts. CIT refers to corporate income tax. And when they use NA, there's no data available to support a meaningful estimation or projection. So I want to take us really to the projections for this year and next year. So they're projecting for 2021 and 2022. With respect to personal income tax, the expensing of current expenditures on scientific research and experimental development is NA. So they didn't have enough data to do any extrapolation. And the same for corporate income tax. Now, with respect to the SRED tax credit, the non-refundable portion for corporate for 2021, it's 850, of course, and we know that that's in millions, and 910 for 2022. And then if we move on to page 41, dealing with refundable tax credits classified, as transfer payments, for 2021, the refundable portion for the corporates is 1,650,000, again in millions, and for 2022 it increases to 1,735, again in millions. And I'll just note that there is some informational literature that everybody is aware of course, on SRED development on pages 178 and 295. I won't go through those, although there is an interesting study that is available starting on page 339, and then it moves on to, I believe it ends at page 361 of the report. So there's quite a bit of pages that are dedicated to SRED. And really the questions that is asked is how responsive are R&D expenditures to tax incentives? And I'm just going to quote from one paragraph there and leave you with that, where the study has shown that about 80% of Canada's support for R&D is delivered in the form of tax incentives, which at the federal level is through the SRED program. The SRED program provides broad-based financial support for R&D performed in Canada through immediate deductibility of qualifying expenditures and an investment tax credit. The ITC rate is enhanced for CCPCs with up to $3 million per year of qualified expenditures, henceforth small firms. Some 26,000 businesses and individuals benefited from $2.8 billion of assistance from SRED ITC in 2018. several provinces also provide similar tax incentives to support business R&D, generally following the federal program, but with varying rates. And they did a study with respect to user cost of capital in Canada using T2 corporate returns from 2000 to 2016. And what they were able to find was that SR&ED ITC is effective in stimulating additional business spending on R&D in Canada, in particular among small firms. Moreover, firms in the manufacturing sector were found to be the most responsive. So, and there are a fair bit of diagrams that are also available with the rest of the study results, and there are also some OECD references that are very useful. So with that, I think I can say goodbye and go to Q&A if anybody has any questions.
Thank you very much, Angela. Not to put you on the spot, and please jump in and correct me if I'm wrong, because I am a little rusty, and I think some of the terminology I'm going to use is going to date me. But when you look at the tariffs and stuff, they talk about $375 for half a day, so $750 for a day's worth of, if you have a senior lawyer, a lot of them in downtown Toronto are $1,200 plus an hour. So, and then the old terminology, is my understanding, was that it's called party and party costs and solicitor and client costs. And that's been replaced many, many years ago with what's now called, as I understand it, partial indemnity and substantial indemnity. And of course, there's full indemnity, which is rarely ever offered. My understanding is roughly substantial indemnity is probably around 75% of your actual costs. I'm just wondering if you have any idea, typically in the R&D cases, what are most of them going to be substantial indemnity, or most are going to be partial indemnity based on the tariffs that I've seen at best? So even if you win, you lose potentially.
Yeah, it's very hard to make any guess on that, Earl, because we have so few cost cases. We have nothing. What I think there needs to be more transparency in this, and this is something that likely should be raised to the powers that be, and it's something that I am thinking of actually raising. I'm actually thinking of applying to be one of the sitting members on the tax court bench and bar committee, and this is, I think, something that needs to be addressed very quickly, because there is no information that is out there on the issue of costs in these very high litigious matters, and matters that where there is a lot of money at stake and where there are a lot of experts that are involved, and because there's going to be a lot of disbursements. And then lawyer time, exactly. I agree with you in terms of the hourly rate, and what you've said is accurate in terms of substantial indemnity and partial indemnity costs. So this is a huge issue, and it's an issue of transparency. And as I've said, the tax court has not been as transparent as the provincial and superior courts of the province, and that's got to change, because we need that guidance. And I can't answer that question, and we should be able to answer that question, Earl, because if we were dealing with other courts, those decisions would be available, and you'd be able to do an extrapolation, and analyses could be done. We can't do it in SR&ED.
Thank you very much. The other thing that comes up from, I appreciate you going through the 417 odd pages so we don't have to, of the federal tax expenditures, but it often comes up in many cases about how much they're spending on R&D. And one of the things was the recent report, well, it's not so recent anymore, quite a few years ago, when resulted in lowering the benefits from R&D. And the logic was because it lowered the tax rates, therefore you can lower the credits against the tax rate. So for the large companies, it went down from 20 to 15%. What the government forgot is that all the other governments at the time were also lowering their tax rates, but they were increasing their R&D benefits. So in fact, I think this had a fairly large impact on us, because as many people know, there's really only three main reasons as to why you locate R&D in a particular location. A, it's close to the head office, because the big bosses like to come in and see what people are tinkering with and creating for the next generation within your company. B, because you do a lot of manufacturing there. And obviously from a Canadian perspective, we don't have too much in the way of either of those, not a whole lot of manufacturing happening in Canada, nor are there a whole lot of head offices. And the third reason, of course, is based on the R&D benefits. And you can see that a lot from even Quebec within Canada. A lot of the pharmaceutical companies are there for that reason. But I mean, they don't seem to see that. So a lot of people are speculating as what might happen in the budget coming up if they're going to touch R&D. I guess we'll find out April 19th, but I don't think they're going to touch it at this point. Clearly, they got too many other things on the table. But if anyone else wants to comment on that, feel free to raise your hand and I will unmute you.
Yeah, I agree with you, Earl. I don't think that this certainly isn't on the radar for there to be any tinkering this year. There's going to be a lot of tinkering on other things. There's a lot of chatter, of course, that they're going to be increasing the inclusion rate for capital gains like there was a few years ago when there was a mad dash to the finish line to deal with a lot of capital gains and a lot of selling off of investments. And then the federal Liberals didn't do anything about it. So we'll have to see. We'll have to see what happens. But I agree with you. SR&ED's not going to be on the table.
I would like to thank all our speakers, David, Ben, Elizabeth, Justin, Angela. I think you guys did a great job. We kept to the time, changed it a little bit. David, I will let you have some final comments in 2 seconds. I just want to say a couple more words. So thank you, especially to David, for organizing this. And if people have some ideas for the next one, perhaps they can shoot it a little further in advance ahead of time to David or myself. We'll see what we can do to put it on the agenda. But I want to thank everyone for their attendance and sticking around, most of you, right to the end. And we will be ending early. But before we do that, I'm going to turn it over to David to have some final comments. Thank you.
Well, thanks, Earl. I think you pretty much summed it up. So if there's any follow-ups, please feel free to email us or the group. And maybe we'll do these twice a year. We'll see. We've got excellent responses, and I've never been more positive about the program. The changes in the last 3 years have been fantastic. So hopefully we'll continue on this trend. And thanks for everyone for helping out and attending. All right. I hope you have a great week.